Please be seated. Call now. Cause number PD-0159-22, the State of Texas versus Jesus Alberto Guzman Curipoma.
May it please the court, counsel. My name is Nelson Barnes. I'm here as an assistant county attorney for Kinney County, Texas, and represent the state of Texas in this cause. We're here today to decide whether or not a writ could be served in any county in the state of Texas for a Kinney County case, and whether that is proper for an out-of-county case or out-of-county court that has no subject matter or personal jurisdiction over a defendant should hear a writ regarding a case in what has been referred to sometimes in the writs here as the distant county.
Counsel, is there a difference between the issuance of the writ and hearing the merits of the application and granting relief?
I believe there is, Judge, that there is a difference between granting the writ and hearing. In fact, I believe there is some case law, old case law, where the court has said you may grant the writ, but you have to hear it in the county where it took place.
Right, Ex parte Patterson.
Yes, sir.
Yeah.
And that we tie a long history of our law, our system, our procedure, is to tie things back to the county where crime took place. That's where we create venue originally in all cases. And we want to go back there because that's where the crime took place. And we're well aware that there's 254 counties in Texas. There are a number of different district attorney and prosecuting authorities, and there's a different community which sees crimes differently based on where they are. And that is tied to our procedure of we put judges there and we put prosecutors there who are elected by local folks to determine how things are handled in a local basis, not to create a jurisdiction where one county can exercise its potentially different views on any given offense before the folks locally can have their say. And with that, I think that we see that in Chapter 11 of the Code of Criminal Procedure, that the courts recognize that there are limits even on 1106, where it is returnable to any county. But in 1142, we're told a court that does not have jurisdiction should remand that case back to the custody of the custodian or provide bail. I mean, if they're on bail, they stay on bail. If they're in custody, they stay in custody. And 1142 recognizes that in that same legislation where they say, no, 1106, we will crush the great writ if we say you can't have it anywhere. But I think this court has long held, let's stress going back to the local court. And let's start there. And when we can't get somewhere there, there's the right to appeal to higher courts and eventually this court. Rather than being in a position of saying, you got to run all over the state and defend yourself from a court that hypothetically and a prosecutor might say. I think forum shopping would then take place, not necessarily for a court, but for a prosecutor. Because as in this case, Kinney County was even told, you can't play. You filed the charges, you determined a violation of law took place in Kinney County, and now we're going to tell you you don't have a say in this anymore.
Well, counsel, I've thought about that forum shopping idea, but isn't a check on that danger the fact that it depends upon the person filing the writ? The prosecution can't go and do this. It really waits for the writ to be filed by someone.
Yes, sir. And then when that writ is filed somewhere else, where in effect not the prosecution would forum shop, but the defense might forum shop for an idea where the politics are different or the views are different.
Someone has an election law violation in Tarrant County, decides that they want to file their writ in Travis County.
Yes, sir.
Yeah.
Or any area. There are prosecutors in the state who have taken a different view on certain misdemeanors such as theft. Mm-hmm. And so could all those writs then be filed in that county?
Yeah.
Yes, sir.
At what point was Kinney County notified that these writs had been filed? Was it before in the process or after the fact?
I believe after the fact. The sheriff was not even told that.
Blindsided an accurate description?
Yes, sir.
Okay.
And that we came to the table basically fighting our way into the proceeding rather than being invited as a participant because we filed the charges. And that is another risk that could happen with this as well.
That's really, I mean, the Court of Appeals basically said you don't have any authority to participate in the proceeding at all, right?
Yes, sir, they did, and basically said that you may have filed the case, may have asked the girl to the dance, but you don't even get to come inside because
No corsage
you're
for
not
her.
on it.
Were you permitted to file any pleadings or anything of that nature, or were you just not permitted to speak at the hearing?
We were given a ability to make a bill
Okay.
as to why we were there, with what credit the court gave to that or didn't give to that.
Just for clarification, how did you eventually find out about this? Were you notified of a court hearing or just?
I don't know, Judge, to be honest with you. I'm not going to try and say I do. I just heard we had this going on. I actually work for multiple counties and am sworn in as an assistant in Kinney to help with that. And I don't know the exact, but we did get word of it so we could at least come put up a fight.
Make a bill?
Yes, sir.
Okay.
Counsel,
Yes,
there's
ma'am.
a number of statutes that provide that the local elected district attorney has exclusive jurisdiction to handle criminal matters within that particular county. Is Kinney County subject to one of those statutes?
Kinney County, as a county attorney, would be partial if a writ was filed in Kinney County to do that.
Is there a government code provision?
Yes, ma'am, that
Okay.
says that, and that would apply with what's filed. We also would urge, that both sides have urged this is a civil matter, that a writ is quasi-criminal civil, and then is filed elsewhere. But what I would argue is that the issue going back completely to even 1101 about competent jurisdiction, that doesn't apply because the court should never have applied. So we wouldn't get to who represents because that court should have said, I'm not the right place for this.
Well, actually, that goes back to my first question. Are you saying, is your argument that, sure, they can issue the writ, but at the end of the day, it's supposed to be returnable to the county versus
Yes, sir.
they can't even issue the writ?
Yes, sir, that it
Which
should
is
be
what-
sent back.
So your argument is that they can do it, they really have a ministerial duty to return it to the county.
Return
as a-
it to the county that either has subject matter or personal jurisdiction. Because hypothetically, Mr. Curipoma could have been held in jail in Travis County on what was seen to be an excessive bond. And he was not returned to Kinney County. I think the judge could say, I'm going to hear this, but they should have Kinney County representatives there for the case and make sure that it is a Kinney representative. And I think the return is the proper method to say, you're right, you have a colorable claim, but here's where you got to go hear it. It's not one that we just say, well, we're going to hear it here. And guess what? Prosecutor filed the case, you don't get to play.
This court recently handed down a decision in a case called Stevens, which was kind of high profile, and in that case, where the court decided that the wrong lawyer was representing the government in the proceeding, the court decided that the right outcome was to dismiss the indictment there. So if this court decides that the wrong lawyer was representing whoever should be represented at the proceeding, should the answer be for us to order the dismissal of the application?
Judge, I would not think that it would be. I do not think we should dismiss the indictment because, again, going back to the first step, we
I think
never
it's not
should
an
have
indictment,
been.
it's an application for writ
Information,
of
yes,
habeas
sir, the
corpus.
application.
I'm not talking about the charging instrument, but the thing that got us to Travis County.
I'm sorry, Judge, I jumped ahead on
It's okay.
on that thought. I do think the court could dismiss that application as that the jurisdiction is not in the competent jurisdiction for the case and dismiss the application and say this should be returned. As 1142 shows is that proper outcome in Article 11. Says if the court doesn't have jurisdiction. So at some point, the legislature must have considered that these would be filed in the wrong place. Or why would we put that language? I mean, I can't imagine that language went in just for the sole purpose of saying, well, if a magistrate court went to do this and it's not one of the listed ones. I don't think that. I think we look inherently at the viewpoint that we want to stay local because that's how it works. Local prosecution, local charges, local decisions. And then there is the appeal protection if that writ is either denied or not heard. And that wasn't done here. And then the complaint is, well, it took too long. Well, the defendant was on bond, and it still took too long to ask. My time is up, and I will step aside.
Counsel, did you reserve any time for rebuttal?
Yes, ma'am,
Okay.
we reserve 5 minutes.
Thank you.
May it please the court. My name is Holly Taylor, and I work for the Travis County District Attorney's Office. I represent the state of Texas in these proceedings. Back in 2001, in Ex parte Taylor, this court said, the state of Texas only has one indivisible interest in a criminal prosecution, to see that justice is done. Article 2.01 mandates that if a district attorney is notified of a criminal proceeding
Counsel.
before a judge.
Counsel, you actually have, like, in your statement regarding oral argument, and this is a question that's weighed on me, that there are possible unintentional consequences from this opinion, from this case. What is it that you think that we're going to be missing? Why should we not say the writ should have been returned to Kinney County, which is where the prosecution started? What are we not seeing?
Thank you, Judge Newell. I would like to address that. I believe that there are potential unintentional consequences in two different areas. One has to do with the role of the great writ in the state of Texas, and the other has to do with the autonomy of an elected district attorney to decide what constitutes ensuring that justice is done in criminal habeas proceedings in his jurisdiction. So with regard to the first point, in our law in this state, we have, as the court I'm sure is aware, Article 11.06, which provides that a writ may be returned to any county in the state prior to indictment. And there have been a lot of arguments about what that means, but I believe that the language is clear. And I believe that that is a venue statute that is intended to effectuate the role of the great writ in this state.
Why isn't that just,
Article 1,
Counsel,
Section 12.
why isn't that simply something you can read to say, hey, yeah, courts have the authority to return it to a county. If someone happens to file in the wrong county, they can return it to the right county. Why can't we just say that? Instead of saying, well, this means that we can keep it in one place. We can just, whatever, it's up for grabs in any county we decide that we want to file in.
Well, for one, there are cases going back at least to 1942 which provide that it means that a writ can be filed in another county. So that meaning has been contemplated by this court and the other courts of this state for at least since 1942, and I believe probably long before that as well. And those cases say that if a writ applicant is not able to be heard or doesn't get the result that he wants in a particular court, that they can file in another court. And there's a history of writs being filed in counties other than the place that they were filed. I believe this was contemplated by the people that wrote this writ originally, the legislature, although to be honest, since that was in 1856, it's hard to go back and find legislative history from that far back.
Sure, absolutely. Don't I know it? But it goes back to the point that I asked previously. Just because the writ is being issued, that's different than being able to hear the writ and decide the merits of the writ and grant relief, right? I mean, sure, they can file it in another county. They recognize filing in other counties in different places. But there's plenty of cases I saw that going back a long time that say, yeah, the appropriate response, though, is to go ahead and say, yes, we can grant the writ, we can issue the writ, but we still have to return it to the county where the indictment or the information is pending.
Your Honor, I think if that were what 1106 meant, it would say that. The legislature would have said the writ can be filed in any county in the state and not the writ can be returned to any county in the
Well,
state.
don't you, but that's right, but shouldn't you be reading in context of the entire scheme? Because 1105 just says that anyone can grant it lists a bunch of judges that can issue the writ, and then the next one is 1106, says it can be returnable to any county. But why does that specifically mean that the writ gets to be heard? Because they don't say the writ can be heard, the merits heard. It just says writ returnable to any county.
Your Honor, the code does define the term return in Article 11.55. And it includes the definition of return as being the service and also the answer by the state. So the answer by the state can occur in any county in the state. And that's exactly what happened in this case. The state answered in this county, Travis County, where the writ was filed, and the district court had jurisdiction under Article 5, Section 8. It was immediately accorded and invoked by the filing of the writ, and Travis County District Attorney is the elected district attorney who has jurisdiction over habeas proceedings under Article 201 in district court, and that term uses shall. It imposes a duty according to the meaning of shall under the Code of Criminal, under the code. So this court has repeatedly said that shall imposes a mandatory duty. Thus, the district attorney had that duty. And that goes to my second part.
So shall, okay, well, never mind shall. So going back to the state can answer, that could be something as broad as they can say, you know what, this shouldn't be here. I mean, is answer defined? So hooking on to Judge Newell's question.
Your Honor, I don't think the term answer is defined in Chapter 11. However, the language that this court has always used for answer and the meaning that answer has had throughout all of writ practice in this state is the answer filed by the state to defend against a writ that is filed in a particular jurisdiction. And this court has recognized the independent nature of the habeas proceedings as compared with the original cause of action. Thus, the habeas proceedings are a separate cause of action that is separately vested with jurisdiction in a court. And so I think that answers your question.
I wonder if I can ask you to entertain a hypothetical for me.
Just,
Yes.
I think Ms. Saylor was going to answer the second part of Judge Newell's question.
Thank you, Judge Keller. Yes.
Not too far.
Judge Newell, I'm sorry, I wanted to return to it. So what I would say is, so I said that there were two parts to my answer. The first part being the impact on the great writ. And I want to say that I think that initially this provision was likely passed because there were situations in this state where writ applicants were unable to get their writs heard in a particular court. Perhaps back in 1856, this was frontier areas where there were judges riding a circuit, which I've researched is the way things were, and there weren't always a judge in a particular county.
Right.
In this particular situation, we have a dire set of circumstances in this particular county where the courts are unable to keep up with the writ filings, is what it appeared to be based on the record that was presented in this case. And thus, an unusual set of circumstances has developed, which hasn't always existed and perhaps hasn't existed for many years, where the courts in a particular county are unable to keep up with the writ filings and honestly timely address claims that need to be addressed immediately under the constitutional mandate that speedy and effectual remedies are available for writ applicants.
Two questions.
So,
Go ahead.
But if Kinney County wasn't even allowed to say anything, how do you know in this particular case that they couldn't have readily gotten to address the allegations?
So, Your Honor, I wanted to get to the other part of Judge Newell's question. Actually, I'm going to address this first, if that's all right with the court. I want to correct a misperception, okay? Brent Smith, the county attorney of Kinney County, was served with this writ when Travis County was served with this writ. The writ applicants served both representatives of the state with this writ. They were not notified after Travis County. We were all notified at the same time. And in fact, I think the court can take judicial notice of proceedings which have been filed in related matters in this court, indicating that Travis County met via a Zoom meeting with Kinney County before this hearing took place, and this matter was discussed. And therefore, Kinney County had full notification of this filing. Kinney County was notified at the same time that we were about the filing, and we did discuss what justice would demand in this case. And ultimately, after about a week, we determined that we thought that justice demanded a different result, and that otherwise there might have been a different result at this time. So Kinney County was served, and furthermore, Kinney County had a representative at this hearing, and that was Mr. Schulman. And although the judge ultimately determined that Travis County was the appropriate representation for the state of Texas in criminal habeas proceedings in Travis County, which I believe was a correct determination based on Article 201 and also 43.132 of the Government Code, which provides specifically for the Travis County attorney to preside over criminal proceedings in the district courts of his district. Nevertheless, Mr. Schulman, as an assistant county attorney for Kinney County, was permitted to participate throughout the proceedings in this hearing and make objections. The court, in fact, responded to many of the objections. The record makes clear that the judge actually listened to the initial objections that the Kinney County assistant county attorney made concerning the nature of the writ itself, and the court actually issued an amended writ at that time during the hearing as a result of that exchange. And Mr. Schulman made objections throughout the hearing, and this was over a running objection, frankly, from me, that he was not the legitimate representative of the state. The court said she was sustaining it, but for the purposes of making a bill, she would permit Mr. Schulman to make those objections. He did. He did object throughout those proceedings, and I want to say something. This venue statute, Article 1106, Mr. Schulman never objected on the basis of that statute. He never used the term venue. He now invokes...
Is venue in the statute?
It doesn't say venue.
Right.
He did not cite this statute. He did not cite Article 1109, and he did not complain that the writ was not being heard in the correct place based on those statutes. In fact, he just asked the court to remand it back to Kinney County, specifically to district court, I will point out, in Kinney County. That was his request because it was more appropriate, not because it was mandated by jurisdictional law, by any particular statute, or by venue provisions such as Article 1106. But to get, I'm sorry, Judge
Please.
Erie.
It's all right.
Can I answer the other
Yep.
piece of Judge Newell's original question? Judge Newell, you asked about the potential impact of this and why I made the points I did in my request for oral argument. And by the way, thank you so much for granting oral argument on this important question. I believe that this is intrinsic to the obligations of district attorneys under the state constitution and under Article 201 of the Code of Criminal Procedure, which not only tasks an elected district attorney with representing the state in criminal habeas proceedings of his district if he is notified of those and is in his district, but also critically not to convict, but to ensure that justice is done. And those decisions on the part of district attorneys in this state are something that this court has recently recognized in State v. Stevens and in many other cases going back through history as being integral to the role of district attorneys in this state, falling under the judicial branch. And I believe that if this court cracks the door open to a party who is not the designated representative of the state under Article 201 to represent the state in criminal habeas proceedings, which this court has repeatedly held are a separate proceeding.
It's Orwellian, though. I mean, that's the part that's crazy. You're saying you're fighting for the autonomy of the Travis County district attorney to handle this, while at the same time interfering with the autonomy of the Kinney County attorney, their ability to prosecute their case. And you're trying to basically grant relief when they may be opposed to it. And yet you're turning around and saying, well, no, this cracks the door open. It seems very more likely that your reading cracks the door open.
Your Honor, we did not go to Kinney County to try to represent the state in those misdemeanor proceedings. We were served with a writ here in Travis County. And by filing that writ in Travis County District Court, the applicant invoked the jurisdiction of the district court and invoked the role of the Travis County District Attorney to represent the state in those criminal habeas proceedings. We didn't ask for this.
Counsel.
We were served with it, and we responded as best we could, scrambling within a week to try to figure out what justice demanded in this case.
You're about to
So-
run out of time, and Judge Jerry's been trying to
right.
ask
I'm
a
so
question.
sorry, Your Honor.
I have a couple of questions. So the first one is a simple one, I think. What is a writ?
It's defined in Article 1101.
Right. And what does that say?
Well,
Let me read it to you. It says this.
Okay, go ahead and read it to me, thank
The
you.
writ is the remedy to be used when any person is restrained in his liberty. It is an order issued by a court or a judge of competent jurisdiction directed to anyone having a person in his custody or under his restraint, that person, commanding him to produce such person at a time and place named in the writ and show why he is held in custody or under restraint. Does the Travis County District Attorney take the position that the Travis County District Attorney at any time had the defendant in this case in his custody or under his restraint?
No, Your Honor, the Travis County
Then
does
how
not.
come you're here? I'm really wondering that, given that this is an application for a writ of habeas corpus, it says that that writ is directed to a person who has him in his custody, and nobody's heard from that person yet.
Your Honor, I would say that it's the state of Texas that has him in their custody, and that there is a history of writs being able to be filed under this statute in counties other than the county where the person was originally arrested. And I would say that also I would point out that this term nexus has been used in these proceedings. I want to point out that the nexus to Kinney County here is actually comparably weak here, as it would be compared to a normal proceeding in which there's a history in this state of writs being filed in counties other than the county where the person was originally arrested, where the crime took place. And for example, sir, I would say this, this applicant was originally from Ecuador. He came across the border seeking asylum, and he was arrested in Kinney County. Yes, Your
I'm
Honor.
familiar with the fact. But I do
So
have one other
he
question
was-
I want to ask, and I don't want to take you too far
So-
out of your time
okay.
zone here. And that question is hypothetical, right? Imagine for a second that there's been a high-profile murder in Travis County, somebody well-known to most people in Travis County, and the DA here announces on television, I'm going to get that guy. We're going to prosecute him to the full extent of the law, and your office is behind it 100%. And that defendant files a writ in, say, Tarrant County. And let's say that the Tarrant County DA appears at that hearing and decides that they want to concede error, that this person should never have been indicted, and they want to dismiss your prosecution. Is your position going to be the same in that proceeding as it is here in this proceeding today?
No, Your Honor.
I don't know why then. Please explain.
Because I'd be happy to explain. Thank you for asking this question. I'm glad you did. We would indict this person in front of a lawfully constituted grand jury, and under the history of the law of this state and under the express language of Article 1106, once a case is indicted, it must be returned to that county where the person is charged by indictment. Therefore, we would simply take the case to a grand jury and indict it, which is exactly what Kinney County could have done here and did not.
Aren't they misdemeanors?
Yeah, there's no indictment forthcoming in this case.
They are misdemeanors, and it is completely lawful in this state for misdemeanors to be indicted in a grand
Yeah,
jury.
but didn't they file the information in Kinney County?
They did file an information in Kinney County.
Which is a typical procedure for a misdemeanor.
Correct, but it is not the same thing as an indictment before a lawfully constituted grand jury, which there's been a lot of historical law that talks about the due process importance of an indictment before a grand jury. It is completely lawful in this state for misdemeanors to be indicted. And this statute, which although it in its original form dates back at least to 1856, was passed again in 1965 when the Penal Code was passed, the Code of Criminal Procedure in its current form. And when that was passed, they specifically continued to use the term indictment here, despite the fact that in other places they do refer to information, such as in Article 1110. They refer to both indictments and informations in Article 1110. So the legislature, we assume that they meant what they said, and they decided to only use the term indictment here and not include informations in that process. And I believe that there's a rationale for that based on the nature of an indictment.
But practically speaking, I mean, in Travis County, you don't indict people and send them to a county court for a misdemeanor. You just there's a complaint and information which vests the county court with jurisdiction over the case.
Your Honor, I'm sorry.
I just don't believe that's the practice in the state, that vests the county court with authority or jurisdiction over a misdemeanor. I can't even imagine.
I'm sorry, do you mean a
any large
district court?
county starting to indict thousands of people for misdemeanors?
Well, Your Honor, I would say that it is uncommon, but occasionally misdemeanors are taken before grand juries in Travis County and other counties in the state. And I want to say that in this particular instance, this becomes something that isn't quite as strange to think about, given that these applicants, as the record shows, were arrested in this county for something that was originally a Class B misdemeanor and was doubly enhanced to a super Class A
This
misdemeanor.
county, are you talking about
No,
Kinney
I'm
County or
talking about
Travis
Kinney
County?
County, right.
Okay.
And then they were quickly processed at a migrant processing center and sent off to a prison in a far-flung county. Thus, they then faced, most of them, weeks or months of prison time before their first court dates. Thus, these cases end up looking a little more like felonies than most misdemeanors.
They were sent to a prison that was, in fact, a jail that was formerly a prison, is that correct?
It was a prison unit that was being used to house these particular individuals. It was formerly a TDCJ unit. I don't know if part of the facility was still being used as a prison or all of it had become dedicated to housing these particular prisoners. This particular applicant was housed at the Dolph Briscoe unit, which is in Frio County, which by my calculations is approximately 97 miles from Bracketville, which is the center of Kinney County. The other Operation Lone Star folks who were arrested went to the Segovia unit, which is about 300 miles away.
Do you have another question, Judge Newell?
I just wanted to, I know you're way past your time, and I'm sure that other people are going to go over it as well, but the question I have is, doesn't the language before the indictment presuppose the existence that someone's going to be indicted? Like, we don't have that in this situation because they've already been charged with an information. So why would we apply a statute that seems to anticipate the potential that an indictment will be filed in a situation where we know an indictment is not going to be filed?
Your Honor, I think this is actually a situation where it would be appropriate for an indictment to be filed because of the special nature of these cases, the extraordinary nature of these cases.
I'm not saying would. I don't think that there's going to be one, and Travis County doesn't get to indict somebody on this, do they?
Certainly not.
You're
No,
right.
Certainly not.
Kinney County does. Kinney County gets to make
That's
the decision,
correct.
and
And-
they've made the decision.
They did. There were other actions that, I apologize, I'm way over my
I know,
time.
I
Do
know.
you want me to continue to?
Yes, I do. I would
Okay.
appreciate that.
So I want to say that filing an indictment was not the only step that Kinney County could have taken in this case. That there was the possibility that, well, number one, Kinney County could have asked for a continuance from this district court, which they never did. I want to point that out as well. The term continuance did not come up in this hearing. No one asked for a continuance to seek an indictment, and everyone knew that if they sought an indictment on this case, it would have forced the case back to Kinney County. They could have held a writ proceeding at that point. They could have resolved this constitutional issue, and it could have been appealed through the normal processes. The important constitutional issues involved here, including the Supremacy Clause issue, could have been addressed by appellate courts all the way up through this court and could have been used in terms of the other writs before those courts. So that could have occurred. In addition, they could have employed mandamus, and as we know, they did that in some other of these cases. So that is another thing that could have happened. At the point at which the 126th District Court issued the writ, which, as Judge Urey pointed out to us under 1101, is the court order mandating this hearing.
Mandating that the person holding,
Right.
the
Yes.
person who has him under restraint
Yes.
should be allowed to come forward and give the reasons why they shouldn't have to let him go.
Yes, Your Honor.
And you
So-
conceded also that the state doesn't have custody or restraint over this individual.
Well, I believe the state of Texas does, Your Honor, and he's being held on bond, not literally by the sheriff of Kinney County. In any event, when the 126th District Court issued that writ, and I believe it was on the 6th or the 7th of January, at that point, I believe the case was ripe for a writ of prohibition. And under Enry Best, I know that this court knows that a writ of prohibition could be directly filed in this court. That could have occurred at that moment, and this court could have, at that moment, decided whether the district court had proper jurisdiction. I just want to quickly note as well that the two issues that the court assessed to this party had to do with the propriety of Kinney County's attorney to represent the state of Texas in the proceedings on appeal and also on PDR, And regardless of whether what the court finds with regard to the district court, I would argue that under Article 4401 and the way it defines prosecuting attorney, that the Kinney County attorney was never the appropriate prosecuting attorney under Article 4401 to file an appeal. The Court of Appeals correctly found that it did not have jurisdiction, and Kinney County was not a party capable of filing a petition for discretionary review in this court under the Naylor case and this court's other precedent.
Thank you, counsel.
I would ask that the court dismiss this petition as improvidently granted. Thank you very much for your time.
Good morning. May it please the court. I'm Stacey Soule, the state prosecuting attorney. I am now the third state entity that is appearing before you.
And everyone else is wrong.
By all appearances, I think the state is having an identity crisis at this point.
My first question was going to be, which part of the state do you represent today?
Yeah. And this scenario really highlights what this court has already recognized, in that the system of prosecutors in Texas is very fractured. That's the way Texas is, like you said, Judge Noel. That's how Texas does it. There's a decentralized government system that also applies to courts as well, and jurisdiction of courts that's in alignment. And one common thread there is based on geography. So we start with this court that has statewide jurisdiction, but it's also just appellate jurisdiction. And then you have the courts of appeals that are split within their own districts that combine many counties. And then you have all the county and district courts, which are divided by judicial districts sometimes. And so there's a local preference here, and understanding that the community in the county elects judges. They also elect their prosecutor. There's a very strong preference for that. And that's one of the reasons I didn't assert my jurisdiction in this case, even though I would say there's no jurisdiction to be here anyway, in the end.
So to be clear, we have multiple entities.
So you're not really here.
Here for the state.
I
So-
wish not.
So your position is you don't really have a place at the table, but you're here anyway. Travis County shouldn't have a place at the table, and really Kinney County should be representing the state. Is that?
I don't think this should have ever been in the district court, period. I don't think the district court had any jurisdiction over this from the get-go.
The Travis County District Court?
Correct.
Okay.
And when you look at this, it's not, venue really refers to where the criminal prosecution, the county in which it initiates. But there's another step in that, and that's jurisdiction. And you have to look at the jurisdiction of the court. And the jurisdiction of the court also has to be proper. And when you go through all of the various constitutional provisions, statutory provisions that are based on maybe a substantive thing or based on a limited jurisdiction, you have your county courts, your constitutional county courts, your statutory county courts, your district courts. There is a mass, it is a puzzle throughout numerous codes to try to pull this together. And sitting down is one of those things where you want to go to a quiet space and sit and really ponder and look through all of these things, because it really is very court specific. And so looking at all of this together at this point in time, and also with the Court Administration Act, I don't see any way that a district court, let alone a Travis County District Court, would have jurisdiction over this case that originates from the Constitutional County Court in Kinney County. And so,
Well, even if there, can I don't mean to interrupt your thought, so please finish it, but I have a question, and
it's
whenever you're
probably
ready
gone.
I hope you'll forgive
It's
me.
fleeting.
But there are, the court talks about jurisdiction in various ways, sometimes it's authority, and sometimes it's like jurisdiction, it's this big concept. And I wonder if there's a way in which, even if we were to find that some district court that did not reside in the county, let's say even far away from the county, might technically have jurisdiction under some circumstances to entertain a writ of habeas corpus. Is there any other concept by which we might say that there's a limiting principle to that,
I'd say they're geographically challenged.
Okay.
And that's the limiting principle that applies
Well, I mean,
here.
we've utilized other sort of concepts to limit, for example, mandamus, right? This court has mandamus jurisdiction, but we don't
Go to the
exercise it when the closer court of appeals hasn't had an opportunity to look at it first.
Yes.
We have there's a spirit of comedy between the two courts that share this mandamus jurisdiction, and ordinarily that spirit of comedy comes into play and allows the local jurisdiction to handle their own stuff, unless maybe there's some real good reason not to do that here. So, I'm just.
I see
I'll
no
let
real
you go.
good reason not to here, because I think 1109 provides an avenue to perhaps, if there was a statutory county court in Kinney County, which there is not, the person could have sought relief there. Or if that's not available, you can go to the nearest proximity judge. And to talk on your point about jurisdiction versus authority, they are two very different things. And I think one way to make sense of it is when you have a visiting judge that's assigned or the other judge welcomes them in, they usually assume the authority of that bench, even when they're being borrowed. So if a district court judge somehow ended up in another county working in a constitutional county court, they can only have the power of the constitutional county court. So that is the authority, they may have different authority, but the jurisdiction of the court is what matters.
Understand. Thank you.
So, as far as I can tell, I don't think 1105 provides any sort of general jurisdiction. It says as provided by law, and this court has indicated when there isn't something specific that doesn't touch exactly on the situation, which I believe 1109 does touch on the situation exactly. It talks about person charged with an offense. We've got our information that's filed in Kinney County. And so there's no need to resort to 1105. In past cases, I mean, it's a murky area of law. I mean, I think Holly spoke to that too. It really is murky. But most past cases have dealt with intra-county judges sitting, not this at odds county situation. So I don't think there's anything really on point for that. Under the statutes, we don't have any kind of visiting assignment or any of that going on here, so it doesn't apply. But when it does, the person has to be invited in. Many of you were trial judges, and could you imagine another judge from another part of the state coming in and imposing themselves on your court? It doesn't work that way. It's kind of like vampire folklore. You have to be invited in. You
So
have
put
to be
some garlic around the door.
So, I'm going to close unless you guys have any questions. Sorry, I said you guys, just
I
keep
did
sort
want
of
to ask
kill
a
me.
question. I did want to ask a question, like, the way, I mean, isn't it, is your argument basically, or is at least one part of your argument that 1109 essentially kind of trumps all these other things? Because specifically when the person is charged with an information, that tells you where you're supposed to go.
Correct. And I think 1106 really is not applicable at this time. Yes, we know that misdemeanors can be charged by indictment, but it wasn't here. And that time period sort of just like ends by operation of law and cuts off. If it were read differently, you would have an extended period of time for misdemeanors over other cases. And the only time that it would actually have a fixed outcome, which is predictable, is in a death penalty case where you can't waive an indictment.
So I also have a question. So, because this case involves the question of the authority of the Kinney County attorney to participate even, right? Which calls into question the whether there's a right to appeal and whether or not there's a right to be here on discretionary review. And so I guess I'm wondering whether, you know, from time to time in our jurisprudence, I've seen cases where the court will have one pleading in front of it, but will decide that, well, that particular, you know, say a writ of prohibition isn't really what you need here. So we're going to construe it to be a writ of mandamus, and we're going to do what needs to be done to effectuate the right answer. Have we ever, in any case, to your recollection, you're the state prosecuting attorney, so to your recollection, have we ever construed a appeal to be, or a discretionary review petition to be in the form, or at least subject to being construed by this court as an extraordinary application for relief, like either prohibition or mandamus or anything like that?
No, the only time I see the court sort of like transforming something that's filed is usually in habeas, where you have a pro se defendant. But it is my position that if the district court did not have jurisdiction, which I don't believe that they did, their order dismissing this indictment really is void, and it's done.
But does it matter what vehicle? Does it matter what vehicle got that question to us?
I think you always have jurisdiction to determine jurisdiction, and this is one of those cases where I think that you need to look at the jurisdiction where it started to sort out that question to end up with, we all should not be here.
Understood.
So, yeah, so if I understand the extent of your argument is if the jurisdiction, if we decide that the Travis County District Court has no jurisdiction, then we don't ever get to answer which prosecutor is the right prosecutor, because no one's the right prosecutor, because the entire proceeding is void.
Yeah, I think it all starts really with the district court. It's not about the prosecutor. Okay. Unless there's any more questions, I will give some time back. Thank you very much.
May it please the court, excuse me, I'm a little nervous. Attorneys for the state of Texas and or the sheriff of Kinney County. My name is Angelica Cogliano, and I, along with Ms. Addy Miro and Mr. Jerry Morris, represent Mr. Jesus Curipoma in this case. We are here today because Kinney County failed to provide meaningful access to the courts in violation of the open courts guarantee provided by both the state and federal constitution. Article 1, Section 13 of the Texas Constitution requires that courts be operating and available, and yet in Kinney County, it routinely took and takes between 40 to 90 days for an RSD to get his first court appearance. Mr. Curipoma waited 3 months for his initial setting. These severe delays threatened to suspend the Great Writ in violation of Article 1, Section 12 of the Texas Constitution. The county and district clerk's offices struggled to even accept and file stamp writ filings, and the district and county courts had a minimum of 6 weeks delay prior to even being able to set these writ applications for a hearing.
Did Mr. Curipoma file a writ in Kinney County first?
No, Judge, and I will explain to you, if you want, why that didn't occur.
I'm very curious about it. I mean, it's interesting to me. I mean, you can argue on the one hand, well, I'm not getting a trial, a speedy trial, for example, right? I'm not getting my speedy trial rights honored. I can't get into court. It's been 3 months. This is a misdemeanor. I want to deal with this and get on with my life. On the other hand, no writ was filed, and I think that if a writ had been filed in Kinney County, how can we extrapolate from the fact that no trial happened to all the way to the idea that if a writ had been filed, it would not have been addressed? Can that jump, is that a logical jump that's too far to make, or is that one that you're asking us to make?
Judge, in answer to your question as to why we had not filed a previous writ in Kinney County, it was because of our experience of the inability to get our writ accepted and heard in the courts. If it was required of us to first apply to that county for a writ and wait and wait and wait for the writ to be accepted and wait and wait and wait for a hearing, in many cases in which we've had to mandamus the local courts to even accept the filings or set the writs for hearing, then theoretical detainees and people such as Mr. Curipoma would have to sit and wait for all of that time before they could be heard, despite Chapter 11 requiring these to be accepted and set for hearing at the earliest practicable time.
Was any consideration given to filing the writ application in an adjacent county?
Judge, In answer to your question, I would have to explain to you a little bit of the procedure before this got heard in Travis County, which I wanted to do in response to Mr. Barnes' assertion that they were not served with this anyway. The way this occurred, judges, I'm a newer attorney. I have never experienced something like we experienced in Kinney County. I was frantic trying to figure out how to get my clients, who were entitled to release in many situations, out of custody. And in doing so, we had a numerous hurdles. And so it was, I think, Christmas vacation. I was home in New York. I couldn't figure out how to get heard. And I remembered being taught that I was allowed to file writs in district courts in any jurisdiction. Mr. Curipoma's was not the first writ we filed in Travis County. A couple of weeks prior, we filed 5 writs in Travis County asserting only our client's right to a personal bond in different cases.
Did you file any in Kinney County prior to filing in Travis County?
Yes, Judge. Yes, Judge. We had filed a number of writs that we had to get mandamus to be accepted, and then we had to file a mandamus in the fourth court to get a hearing set on those issues. This has been a recurring issue, as is evidenced in the record, both by testimony and exhibits that were attached and admitted at the hearing.
You mentioned that it was, the statute requires as quickly as practicable, is that right? But you're talking about hundreds and hundreds of these misdemeanor charges for different defendants. So it seems that as soon as practicable was going to take a while.
Yes, Judge, and I'm going to respond to you, and then I'll get back to your question, Judge. I urge the court to, as other counsel here have suggested, to read Chapter 11 as a whole. And so, yes, while it may have been a delay before it was practicable in Kinney County, Article 1104 and the other provisions require that all of Chapter 11 be read so as to effectuate not only the remedy that the applicant is entitled to, but the speedy and effectual remedy. And so in that case, that is why I believe that this chapter allows for several courts to have concurrent jurisdiction over applications for writ of habeas corpus, so that in conjunction, any applicant who may be unconstitutionally restrained may be heard quickly in whichever court that is able to happen.
But counsel, your client was on bond, correct?
Yes, Judge.
So don't you think then for the courts that they would rather address the folks who were in custody first before addressing your client on bond, because he's not, truly restrained of his liberty? He's got the bond, but he's allowed to go out and do what he needs to do and not be in custody.
Yes, Judge, and I think that if the Travis County District Court had declined to exercise their jurisdiction for that reason, that would have been, a reasonable way for the Travis County District Court to decline to hear this case. They felt that court felt that despite the fact that Mr. Curipoma was on bond, that he was entitled to relief, he was being unconstitutionally restrained, and therefore it was that court's duty to issue the writ and set it for a hearing. And in response to your question, Judge, about what happened, when we filed our first writs in Travis County, before the clerk even accepted and file stamped them, Mr. Schulman, on behalf of Kinney County, emailed the presiding judge of Travis County asking her to direct the clerk to not even accept our filing. That was not a filed response. That was not a formal objection. It was an email. I was copied on the email. In that email, he suggested that I could apply in counties other than Kinney County, but that he would prefer that it be one of the counties that are closer to Kinney County than Travis County.
Are those emails part of the record in the case?
No, Judge, because those are separate writs, and I'm only offering this because it was asked of opposing counsel if he was notified, and I want to explain a little bit the extent to which they were notified. Those writs were accepted. Kinney County, subsequent to that, agreed to personal bonds on those cases, which they hadn't agreed to previously, despite those clients being entitled to them. And then I called Mr. Schulman on behalf of Kinney County, and I said, since we have a writ setting, I have another writ that is on different grounds. Is it okay with you?
This is not part of the record. You probably should not be talking about it.
Understood, Judge. And again, I only went there because I wanted to clarify. So Kinney County and the District Attorney's Office both had the same notice and official service of this filing that occurred.
How long was Mr. Curipoma incarcerated before he got bond?
Judge, so Mr. Curipoma was incarcerated for, I believe, 29 days, and this is a part of the record. And his experience also describes some of the other issues we've been having in Kinney County. Mr. Curipoma was charged. He never received an attorney or a court date for a long period of time. He did pay cash bond. Despite paying a cash bond, he was still restrained and not released from custody from Kinney County. When he first contacted us to get help getting out of custody, we made Kinney County aware of the situation. At that point, they contacted ICE and issued an ICE detainer, despite the fact that he was entitled to release far before that and there was no ICE hold. Following the 48 hours that ICE holds apply under Texas law, he was still over-detained for several days, I believe up to a week, being held by Kinney County without their jurisdiction to hold him in custody in any manner. What we have experienced in Kinney County is an outlier. Even separate from the unique circumstances of Operation Lone Star, Kinney County is the only county that we have been required to take these drastic measures. It's the only county where they routinely hold people in custody without a charging document up to 10 months with us unable to be able to get a hearing. And it is because of that action and inability of Kinney County to provide us access to the courts that I believe that the Travis County District Court exercised their discretion and authority to grant this writ and set it for hearing, understanding the extreme circumstances that are occurring in this case.
So who is it who took Mr. Curipoma into custody and who held him under restraint?
So when he was first arrested, he was held in custody because of an arrest made by, I believe it was DPS, and he was technically, while in custody, under the restraint of the sheriff of Kinney County.
Okay.
Once he was out on bond, I believe that he was being restrained by the state of Texas because the information is filed on behalf of the state of Texas. And that gets me to an answer to one of your previous questions, Judge, about what is a writ and what is a writ return. A writ, the application for a writ is simply a request of a judge to issue an order that a hearing be conducted. Simply, period. It is not the merits of the underlying application, nor is it the relief that's granted subsequent to the hearing. Texas jurisprudence acknowledges two different returns that happen in writ cases. One is the return that simply, if a sheriff has someone in custody, saying, yeah, I have him in custody and I will bring him, not the merits of whether or not his custody is constitutional. That is separate from the return of the writ to a county for hearing on the merits, which is what the return provision allowing return to any county in the state allows. And so those are two separate provisions in this case.
So when somebody makes bail, right, to whom do they pay the money to secure their freedom from custody?
To the sheriff of the county.
So the sheriff of Kinney County is the one who's holding that money on behalf of the assurance that he will appear.
Judge, I believe you can apply for a writ based on restraint by being under bond or restraint that's by virtue of being under information or charged with a crime. And in our case, we applied for this writ based on the theory of restraint that he was charged by an information by the state of Texas.
But while he's being held on bond, right, the sheriff of Kinney County is the one who can say this is insufficient, right? I mean, the sheriff of Kinney County is the one who is accepting that money in return for his release. And if the sheriff of Kinney County decides that, oh, well, this is actually counterfeit money, for example, that you posted for your bond, what does he do? Would he take him into custody again?
Presumably.
So he's technically, correct me if I'm wrong about any of this. It seems to me he's being held principally by the sheriff of Kinney County. And I'm wondering in what sort of legal universe where a writ is described by our statutory law as an order to the person holding someone and giving them an opportunity to come forward and say why they can be held. In what world under what legal circumstances can a trial court judge say, you don't speak?
Judge, I have a few answers to that question. Okay. The first is I would let the court, or remind the court that often there are writs of people in custody and writs with people that are on bond, and never in those situations, in my experience or any that I've heard of, has the sheriff of that county had a representative at the hearing specifically for that sheriff's interest. And so for that reason, I don't believe that the sheriff of Kinney County has a say in this proceeding in general. Additionally,
So you think he doesn't have a say just because you haven't been aware of it being done before?
there's no provision, so the return that the sheriff is allowed to provide if they are the one restraining them is specifically defined in Article 11.3, which is how the return is made, and that articulates what is included in that answer by a sheriff or whatever other entity is holding the person in restraint. And that simply says whether or not it's true that he has the person in custody, by virtue of what authority, not the validity of that authority, but why he's holding it. For example, this person's been charged with a complaint and there is an order, a PC affidavit and a commitment signed. If they've transferred that person to another person's custody, and then he must sign it and it must be sworn. And so the return in that context, that it should be provided by the sheriff or any other entity holding someone in custody, is not for the merits. It's simply to let the court issuing the writ know that he has the person and will bring them to the hearing. And I would point out that even the Chapter 11 provides in Article 11.31 that if that person doesn't respond, if that person doesn't even bring the defendant to the hearing because they don't want to respond or don't acknowledge the authority of that writ, the hearing can still proceed as long as the defendant's counsel allows the hearing to go on. And that is because the jurisprudence, and I forget the name of the case, and if you will all allow me to brief it, I can provide it. When this court determined the civil/criminal nature of a habeas proceeding and that it is a separate and distinct proceeding, that is based upon the fact that it's not a lawsuit. A lawsuit is two parties that are contesting each other's position. It's titled ex parte defendant or applicant, ex parte Curipoma, because a writ proceeding is one person availing themselves of the potential for relief by a court. There is jurisprudence, and I will submit that to the court if the court will allow it, where it's even said that notice isn't required. I am not required to notice any party for the state of Texas when I file a writ. The clerk has been directed by this court and in other instructions that the clerk, if they receive an application, should forward it to the appropriate party for the state, but that is not my responsibility, and I am not required to provide notice for anyone. And that is because all I am alleging is the constitutionality of restraint, not the merits of the underlying prosecution. And I would remind the court how rare it is to have a cognizable pretrial constitutional claim in this case. 99% of pretrial writs are simply asking for a bond reduction or a personal bond or a change in bond conditions. I searched the jurisprudence in appellate courts on pretrial constitutional claims, and in no case in the past decade has any one appellate court had more than 8 cases where they're dealing with a cognizable pretrial claim, and in much fewer of those has that cognizable claim been meritorious.
Counsel,
it is rare.
Counsel, you had mentioned this, and this is something that I brought up from the very beginning. You had mentioned there's a distinction between hearing the merits on the application and the return of the writ. Why isn't the answer simply to return the writ? Like, sure, the statutes allow for the district court in Travis County to issue the writ. Why isn't the appropriate response, though, based on our case law, to just say, yes, we're going to issue the writ and we're going to return it to Kinney County so that Kinney County can hold the hearing that you say that you're entitled to?
You know, Judge, I think that is a valid preference. I think that maybe the reason this issue hasn't been brought before the court is that if someone has applied recently in an extraneous jurisdiction or extraneous venue for this, that court may have granted the writ and returned it to the county of original jurisdiction over the criminal prosecution. But I would submit to the court that is not required. It is permissive language. This court has routinely...
Well, it may be required by our precedent. I mean, we do have precedent that says the appropriate return is to the county where the indictment of the information is filed, even when it's out of county.
So, Judge, the precedent that uses that language that I am aware of in this court is referring to this court's original jurisdiction, and in those cases, this court has articulated the difference between the Court of Criminal Appeals and district trial courts that have the ability to hear evidence and conduct a hearing. And so my position is that the CCA jurisprudence on this issue, when it describes how they are not going to, this court is not going to invoke its original jurisdiction, is based largely on that that
Well, let me
procedure.
ask you, let me back up and ask a broader question. Can you point me to any case where someone is being charged in, say, one county, like Kinney County, and then they're nevertheless filing a writ in Travis County, or say Tarrant to Harris County, or whatever, where they've said, yeah, we're gonna hear the merits of that writ?
Judge, outside of the jurisprudence that was cited by the Travis County District Attorney here, that goes back to the 1980s or the 1920s, I don't. And I believe the reason for that may be twofold. One, district courts probably have often refused to invoke their discretion to hear these on an out-of-county writ, just as the state prosecuting attorney asserted to you all, could you imagine this occurring? I think that is a huge gatekeeper on this. The reason why it's not going to cause floodgates of extra venue, I don't know the word for extra venue that's parallel to jurisdictional, but that is one of the major gatekeepers after cognizability that would prevent this from happening all over the state. We would only have jurisprudence on it if that occurred, and then it was appealed, and then it was reviewed. And I think that's exactly why this court shouldn't be fearful of the result of this case, because despite this remedy being available, it has very rarely been invoked or been granted the discretionary review by extra venue district courts.
But y'all would sort of break the seal on that. I mean, like after you, the après-moi la deluge.
Judge, let's say, for argument's sake, that you're right, that after this case, if you guys allow this to remain standing, that there are suddenly thousands of writs being filed in venues outside of where the criminal prosecution is occurring. There are a multitude of what we've deemed off-ramps before that occurs. Cognizability, meritorious cognizability, a district court exercising their jurisdiction, a district court exercising their jurisdiction and returning it to a specific venue, a local district attorney inviting a local prosecutor in and not exercising their ability to litigate it, the district court not granting the writ for review, and the local prosecutor applying for a writ of prohibition to prevent it if for some reason it is distinguishable from all of the other cases in which somebody may apply for relief. The idea that this is suddenly going to cause the dismissal of prosecutions is really unfounded and hyperbolic, because very rarely, very, very rarely, is even the remedy for a pretrial application of writ of habeas corpus dismissal of the underlying charges. It just doesn't occur.
That's pretty speculative on your part. You're guessing that that's the situation. One thing I've noticed is I believe the question was posed to you, why didn't you file this in a neighboring county rather than in Travis County? And I don't think you ever answered that.
I think you're right, Judge. I never got to that final point. You're right. So the reason we picked Travis County, honestly, for the first point is just because I'm a newer attorney and I simply knew the e-filing practices in Travis County. I didn't know if it would be accepted by the Travis County District Courts. I actually didn't expect the Travis County District Attorney to avail themselves of the opportunity to represent the state. And that is one reason. The other reason is because Travis County District Courts have specially...
Excuse me, I'm sorry, but I thought you said earlier that you have filed writs in other cases in Kinney County.
Yes, Judge, just not in this
Not
case.
in this case, but
Correct.
now you're saying that in this case you filed it in Travis County because you're just more familiar with e-filing. But weren't you familiar with the way to file it in Kinney County already?
Yes and no. So first, Judge, it's been an evolutionary process filing things in Kinney County. It's been difficult.
It's a journey.
Yes, I think the Kinney County clerk and the prosecutors and the defense bar litigating there have been together figuring out how to do this, because Kinney County hasn't heard a criminal prosecution in the 2 years prior to Operation Lone Star at all. But a second answer to your question is I didn't mean I only knew Travis County e-filing. In general, I knew that I couldn't get heard in Kinney County, and if I was going to file a writ in a county other than Kinney County, the county that I knew how to do it the easiest and best was Travis County. Additionally, Travis County courts have special jurisdiction beyond any other court in Texas. The legislature has availed Travis County Court of specific kinds of prosecutions because it is the location where the capital is, because it's the location where the governor exists, and it's because it's the location where the Court of Criminal Appeals occurs. And so if there was going to be a county other than Kinney County that theoretically could hear this case and have jurisdiction to do that, Travis County would be most likely to be that court. I'd like to turn quickly here.
I just want to make sure, though, because I did interrupt your answer to Judge Slaughter's question. Did you answer her question? Yes. Okay.
The next thing I'd like to point out, Judge, is it truly is not one of the issues granted review here. The issues granted review in this case, we are here because of Kinney County's inability to provide open courts to its defendants. But that's not what we are here to
The problem
decide.
is, in this case, the writ was never filed in Kinney County. All the other cases are not part of the record. You didn't file a writ on this case in Kinney County, did you? And then you get turned away?
No, Judge, but if.
You started in Travis County.
Yes, but in our hearing, we not only had testimony from several witnesses about the lack of open courts in Kinney County and their availability, we also attached to our application several exhibits that are describing our inability to get a timely hearing on any matter in Kinney County. And so that the only evidence in the record is that the courts were not functioning despite the assertions made by Kinney County in their filings here. They didn't offer any evidence at the hearing or otherwise to show that we're wrong on that issue.
But at the time you filed the writ, your client had been able to make bond in Kinney County, correct?
Yes,
And I
Judge.
assume that took some sort of a judicial process.
It took several judicial processes,
Okay,
Judge.
so he made bond.
Yes, sir.
So once he made bond, why not, in order to preserve your claim that he wasn't getting any type of remedy or relief, why not file the writ in Kinney County, and if it didn't work, then take it to Travis County?
So my first answer to that, Judge, is because I wasn't required to. There's nothing in the jurisprudence or in Chapter 11 that requires me to file first before availing myself of a different district court. Second, the reason
Which is
that.
why we're here, because that appears to be a gray area, that you jump straight to Travis County.
Judge, I believe that the Chapter 11 is clear and straightforward. It has several provisions, including, I would direct this court to Chapter 11.51,
Right.
which under 11.53 only applies to pretrial writs of habeas corpus, where it says if the hearing is heard out of the county where the offense was committed, then the clerk of that court will provide a copy of the proceedings back to the county where the criminal prosecution is laying at that point. And so that even in the language of subsequent articles under Chapter 11 is clearly articulating the acknowledgement that Chapter 11 is allowing extra county writs to be filed in certain situations as long as an
We have
indictment.
three representatives of the state here.
Yes,
I don't know that any of them agree on what they're saying. So I don't think it's as clear as you think it is.
Sure, Judge, and of course, it's going to be up to this court to decide whether that means that or
How
not.
long did it take you to get your guy out on bond?
So he was in custody for 29 days. I believe, and if you allow me to confer with my co-counsel, I think she has the exact number of days, but it was several weeks, if
So-
not
so
months,
as soon
after
as
he
he was
posted bond for us to be able to get him out, despite him being entitled to release the day he posted his cash bond in Kinney County.
Okay, but, so from the day he was incarcerated, that's when you started proceedings to?
No, so we became aware that Mr. Curipoma was being over-detained subsequent to him being over-detained after posting bond. He had been,
Well, what I'm getting at is, you're saying it takes forever to get anything done in Kinney County, but apparently you were able to get him out on bond in Kinney County. So if that happened rapidly, I'm kind of curious about other things you say Kinney County can't do.
so first, Judge, it was certainly not rapidly that we got him out on bond. It took a lot of effort, but that didn't require a hearing. That was simply reminding everybody in Kinney County that when somebody posts a bond, they are entitled to release as soon as possible. And so that was coordinating with the sheriff's office, with the person who was new to bonds, making sure that he understood where everything had to be processed. A lot of the delay was due to the logistical confusion between the Val Verde Processing Center, in addition to the sheriff of Kinney County, and this is in the record, testifying under oath that his intent was to keep Operation Lone Star defendants in custody as long as it took, despite the fact that he's required to release them. And that was submitted as an exhibit at our hearing, in contrast to an affidavit that he had filed in a federal court, which is also in the record in this case. And so the mechanism used to release somebody who has paid cash bond already is different than getting heard on the merits of a writ of
I
habeas
realize
corpus.
that, I'm just, because there are allegations that Kinney County apparently is doing nothing, so I was
And
curious.
Judge, and this is also in the record, representatives for the Border Prosecution Unit and Kinney County have acknowledged to the legislature at funding committee hearings that things had been very difficult, that logistically things weren't being heard in a proper way. People were being detained far in excess of 17,151, and they've acknowledged that in front of the legislature.
You had mentioned earlier about there's no requirement that you seek a writ in Kinney County versus seeking, but we actually have a mechanism for where we exercise our mandamus jurisdiction when we have concurrent mandamus jurisdiction with the lower court, which is we actually have held and we require people to file in the Court of Appeals. Why can't we just say that in this case you are required, even though you have concurrent jurisdiction, you're required to at least first file in Kinney County?
Judge, this court deciding that it's only going to exercise its discretion in a given situation is certainly within the province of this court. For this court to then determine that a district court that has its own discretion can only utilize that discretion in certain situations, I believe would be this court legislating from the bench, which is not how case law is supposed to be
Actually, I'm
interpreted.
glad you mentioned the legislating from the bench thing, because I don't read these statutes, 1105 or 1106, as limiting the ability of anything. And like you're saying, well, it can go into any county. So you're saying in Travis County, and that means to the exclusion of Kinney County. I see them as simply granting the ability for courts to hear it, for courts to be able to hear those things. But it's still up to us and our precedent to determine how those cases are heard.
Yes, Judge.
Yeah.
If this court determines that it has the authority and is going to put new limits on the ability of district courts to exercise their original jurisdiction, then certainly that is, within the province of this court. I'd like to point out that the state prosecuting attorney has argued that no district court has jurisdiction to hear applications for pretrial writs of habeas corpus on misdemeanor cases, and there is a plethora of jurisprudence out of both this court and the courts of appeals in which there is no difference of opinion that district courts have concurrent jurisdiction over pretrial writs of habeas corpus. Ex parte Schmidt, which is a 2003 case out of the Court of Appeals, and Rodriguez v. Onion, in which this court stated that 1105 is dispositive on the issue of jurisdiction and that it always creates concurrent jurisdiction for those cases.
But that goes back to what I mentioned to the state prosecuting attorney. 1109 specifically refers to a situation where someone is confined after the charging instrument has been filed, which we have, right? So
Right,
why wouldn't we say, that's not legislating from the bench to say 1109 requires that you go to that county or any county adjacent, not to Travis County?
So, Judge, there's no case law or statutory provision that articulates a county nearby as preferable over any other county in the state. And the 1109 is permissive language, and that is why this court and all of the courts of appeals have read that as concurrent jurisdiction between the district courts, even when an information is filed.
So you and I disagree when the statute is permissive versus when it's limited.
Yes, Judge, and this court's jurisprudence has been very clear previously that district courts, whether this court decides that venue is available for review in this case, despite it not being objected to at the trial level, if this court determines it is reviewable in this case, that's separate from subject matter jurisdiction of district courts, which in Rodriguez v. Onion, Rodriguez v. Court of Appeals, in Ex parte Williams, Ex parte Felper, Ex parte Johnson, and I can provide more of these to the court if that's requested. Concurrent jurisdiction of district courts generally it is concurrent with misdemeanor courts even after an information is filed, and that's separate from which county in which an application can be made. I think I'm over time now, Judge, so unless there's any more questions, thank you for hearing us today. I know this is a complicated issue.
Thank you, counsel.
May it please the court.
Another state's attorney.
Counsel. It won't be long. Where to begin? There is no concurrent jurisdiction. I would suggest that every case in the past which suggests that there is concurrent jurisdiction based on the May in 1108 and 1109 are wrong. When my mom would say to me, "You may do this," I knew that what she meant was, you may not do anything else. And that is what 1108 and 1109 mean. You may apply to this court, your own court. If that court's not there, it's not available, you can go to a county court in an adjacent county. And if they're not there, you can go to an adjacent county. But in every case in 1109, it is to a county court. And I think that all the cases before this suggesting otherwise are wrong. Second, nothing in 1106 pertains to jurisdiction. It is, as I think Ms. Taylor said, a venue statute. What it means is not clear, but is predicated on the issuance of a writ already taking place by a court of competent jurisdiction. And if a district court in Travis County is not a competent court jurisdiction, then where the writ may be returned doesn't matter. Third, no writ was issued in this case. If you review the record, you will see I pointed out to the district judge, that the document purporting to be a writ was not a writ, because what it did was order the district clerk to do something, not the custodian. A recess was taken and a new document was drafted which instructed the sheriff of Kinney County to do something, but there was no attempt to serve it on the sheriff of Kinney County. And in fact, there is no return on that document. It's simply an order doing this. Now, I will tell you that I read each of the previous codes of criminal procedure, all the way back to the 1856 code, which
Are
was...
you that old?
Sometimes I feel it, Judge, but no, I read those recently. And actually, I will say that this case is a lesson in how your education is never over. Because I've been telling people a long time what people told me, yeah, 1106, you can do anywhere, wherever you want. But when you read it carefully and you go back to the 1854 code that became the law in 1856, they were talking about the return. Came to my hand at this time, did this. Who's going to keep that document? Because it's an important document, and as you may know, all these counties between El Paso and here didn't exist. That was all Bayer County. So if somebody was arrested in El Paso, who's going to keep the documents? Well, an indictment, send it back to Bayer. It's not an indictment, you can keep it here. But the other thing, too, is if you review the 1854, 1856 code, they clearly did not mean the hearing, because they didn't refer to hearings. What happened after the writ was issued, they referred to as the trial in habeas corpus. It was a separate trial, having to do only with the habeas corpus. The prisons, there are two of them. They are by agreement between Kinney County and the Jail Standards Commission, extensions of the county jail. They have to comply with all terms of county jails. There's other counties storing people there, and for example, several of the counties, they don't even have a jail. Doesn't work. Maverick County doesn't have a jail right now because it won't match jail standards. How important is this? What's the effect on habeas corpus? The order in this case was issued on January 13th of 2022. On January 14th, 2022, in case D1GN22302 in Travis County, which is before you as WR 93-35402, Smith versus Judge Swaffer, the day afterwards, 400, somewhere between 444 and 481 writs from Kinney County cases were filed in Travis County and ended up in front of Judge Swaffer. The words you should be concerned with are, in fact, forum shopping. And the hypothetical I heard taught around was not somebody down here in Tarrant County. It was, well, somebody down in the coast who plays golf with a district judge up in Farwell. Forum shopping is the problem, and it will be a problem. Unless anybody has any questions, thank you for your time.
Thank you, counsel. The case is submitted.